Good morning. Happy Valentine's Day.
Gay couples have scored a legal victory in Virginia, where a federal judge has ruled the state's ban on same-sex marriage is unconstitutional.
Today, we are more American than we were yesterday, and today, we're a little more equal than we were the day before. Thank you.
The state of Virginia now joins 4 other states where federal judges struck down state laws on constitutional grounds in less than 2 months, dramatically expanding gay rights across the country. And all of these rulings in all of these states point to one man as the inspiration for their opinions.
Gee, I really don't want to get in. I mean, get over it. It's so old by now.
Yes, conservative Supreme Court Justice Antonin Scalia.
You would be surprised.
Last year, while the progressive world rejoiced when the Supreme Court struck down the Federal Defense of Marriage Act, Antonin Scalia was absolutely indignant.
Kennedy's grand opinion drew a blistering dissent from Justice Antonin Scalia, who called today's ruling jaw-dropping and accused Kennedy and the liberal justices of declaring anyone opposed to same-sex marriage an enemy of human decency.
Scalia's scathing dissent mercilessly mocked the majority opinion, which specified that while the court was striking down DOMA, its ruling did not apply to state gay marriage bans. In a 26-page rant, Scalia took a knife to that logic, even writing a fake ruling showing how easily the majority opinion would be used to strike down bans across the country.
In his dissent, he takes part of the majority opinion. He says, hey, guys, this is how you take the majority opinion. You cross out a few words, and what you end up with is this identical argument to strike down every ban of marriage equality across the nation.
At the time, some noted how Scalia's dissent could actually be used to further the cause of gay rights.
He says it is only a pretense that today's prohibition of laws excluding same-sex marriage is confined to the federal government. He says the other shoe will drop about state laws banning same-sex marriage, quote, later, comma, maybe next term. You think he's right?
Yes, we now know Scalia was right. And he was so right that his vitriolic but prescient dissent has now been used by 5 federal judges to expand gay rights. In Virginia, Judge Allen wrote that if the Constitution was used to protect the rights of gays and lesbians in the Supreme Court's DOMA ruling, the same argument would apply to state laws. Allen writes this idea is, quote, described eloquently in a dissenting opinion authored by the Honorable Antonin Scalia. In Kentucky, a federal judge worked in a rhetorical homage to Scalia's dissent. In Ohio, Judge Black wrote, just as Justice Scalia predicted, the lower courts are applying the Supreme Court's decision as they must. In Oklahoma, the federal judge similarly cites Scalia's masterpiece. In Utah, Judge Shelby wrote, the court agrees with Justice Scalia's interpretation of Windsor. So congratulations, Justice Scalia. In your obnoxiously brilliant attempt to skewer the legal reasoning of your colleagues, you've made yourself the unlikely hero of gay rights.
And joining me now is Camilla Taylor, the Marriage Project Director in the Midwest Regional Office of Lambda Legal. So, Camilla, after Windsor was handed down, there was a real open question as to how lower courts would interpret the decision. Would they interpret it narrowly, which is part of what the majority opinion seemed to be suggesting about itself, or would they interpret it in the way Justice Scalia did, which was to throw the barn door open for marriage equality everywhere? Are you surprised with which the unanimity has been to confirm Scalia's interpretation?
No, Chris, I'm not surprised. But I would like to join you in offering my heartfelt thanks to Justice Scalia for his very useful words. But actually, the majority opinion itself was very clear that the opinion was grounded in principles of equality and liberty. It was not a decision about federal authority, as some were trying to portray it, but instead it was about human dignity. So while Scalia's words were certainly very helpful, the words of Justice Kennedy, who authored the majority opinion, have been the most soaring rhetoric and the most wonderful undergirding of a lot of the decisions we've seen.
Joining me now, politics editor, a Business Insider, and MSNBC contributor Josh Barrow. So, the pace at which this is moving legally is amazing. Mm-hmm. The pace at which it's moving in public opinion is equally amazing. Astonishing, even, I would say. Mm-hmm. Institutionally, the Republican Party seems to be dragging its feet a little bit on this.
A little bit, but you're seeing an interesting split. We were just talking about the Ninth Circuit and that decision about laws that discriminate against gays. That underlay a decision in Nevada in the last couple of weeks not to pursue an appeal of the state's ban on gay marriage. And the Democratic Attorney General and the Republican governor both said, we don't think we can win this lawsuit anymore because of what the Ninth Circuit said. We're not going to bother pursuing this anymore. Sort of similar to what Governor Chris Christie did in New Jersey, where he was appealing the decision against the state's gay marriage ban for a while, but he reached a point where he decided it was game over and he wasn't going to bother appealing it anymore.
Yeah, so this is the kind of non-defense strategy that we've seen emerge, in which basically state attorneys general say we cannot in good faith try to constitutionally defend this prohibition.
So you're seeing some of that. On the other hand, we had what happened in Kansas this week, where the Republican held House of Representatives passed this bill that created all these new special rights for people with anti-gay views, or would create that if it becomes law.
It's basically a segregation bill. It is. It would legalize segregation in public accommodations against, you could keep gay people in a separate, I don't know, separate but equal.
Well, that's already legal in Kansas. It's not a state that has a ban on discrimination against gays. So you can already say, I'm not going to employ gay people and things like that. The new rights that this law would create on top of that is it would say if you work for a company and that company has a policy against anti-gay discrimination, you're still allowed to say, well, I'm the bakery guy at the national chain supermarket, but I'm not going to make a cake for this gay couple's wedding. And the company has to find somebody else to come in and make the cake for them. And similarly, public employees would be able to say, even if it's part of my job to provide a certain service to say, to process a foster children application for a same-sex couple, they would be allowed to just say, I'm not going to do that.
So the question about the Kansas law, which I think we all read about this week and thought, this is horrible, and also I think obviously facially unconstitutional given the court's jurisprudence at the moment. What is this, just the kind of last dying embers of hatred, or does this signal that there's going to be some kind of real genuine backlash energy in the grassroots of the Republican Party as they continue to see the kind of gay rights agenda spin out of control?
I think it's a couple of things. I think it's the last dying embers of hatred. I think it's also a sense among social conservatives that they're under siege, that they're the ones who are really oppressed here, and so the whole bill is framed as a religious freedom bill. But I think it's dying embers. The Republican president of the state Senate in Kansas said she has a lot of concerns about this. She's not for gay marriage, but she thinks the law protects discrimination too much. So it's not clear that even in Kansas, which has a huge Republican majority in its legislature and has Sam Brownback, who is a leading social conservative, as its governor, even there this law might not pass.